by the order of this court, it will still be served on you. And that it is at that point that you come in and you make all this, raise all this objection. At that point, you can now ask for a setting aside of the judge of the garnishing nicer. But I cannot hear you at this point.
Court pleases.
Thank you. So the order will be served on the judgment debtor and the garnishes. It is at that point, of course, there will be an order that they should come and show cause. It is when you come and show cause that you now exhibit all this. But hearing you at this time is not the procedure of the court.
Court pleases.
Court application granted. An order nisi is hereby issued against the first, the third, and the eighth garnishes, namely First Bank PLC, United Bank for Africa PLC, and Unity Bank PLC to show cause why they shall not pay to the applicant the sum of 8,885,643 naira 38 kobo only awarded in favor of the applicant and suit number NICN LKJ 33/2020. The judgment debtors had failed and or refused to pay, and with sum now stands to the credit of the judgment debtors in their accounts with the garnishee banks. The account numbers are First Bank PLC, account number 20322984468 and 200-535-8793. UBA PLC, account number 102194441 and Unity Bank PLC 00245-32224. This order shall be served on the judgment debtors and the garnishes. The garnishes shall show cause within 14 days of being served with the order. The matter is further set down till I'll give you a date. So, Mr. Ekpa, whatever objection that you have to this garnishee order, it has not been made absolute. You can file any process at that point.
Court pleases. We're most grateful, my Lord.
The cases adjourned to 17th of June, 2025 for the garnishes to show cause.
Most grateful, my Lord.
You have all the time to file whatever you need to file now.
As court pleases.
Let's call the next case, please. So I've already removed this.
And yeah, you know.
NICN LKJ 29/2022 between Nigeria Union of Road Transport and Madam Bala trustees of Kogi Trust of Nigeria. Other parties are absent.
Parties absent, appearances, please.
Maybe, my Lord. I am MJ. John.
Yes.
OH.
Yes.
IEKU.
Yes.
My Lord, I hold the brief of J.U. Barra for the claimant. J.U. Barra for the claimant.
Yes. Any representation for the defendants? Okay. For the yes.
Is for the defendant.
Yes, ruling.
We are read, my lord, subject to your lordship convenience.
Convenience as to what? In summary, the claimants alleged that the defendants are transporters and members of the National Union of Road Transport Workers, hereinafter called NURTW, and that being within the jurisdictional scope of the claimant, they are thereby bound by our rules and regulations. The claimant further alleged that the second defendant is not a registered trade union and contends that being drivers in the transport business and for effective supervision of their business, the members of the second defendant are obligated as provided by law to join NURTW, the Registered Transportation Trade Union. Based on the alleged infractions of the defendants, the claimants took out an originating summons in this court on the 29th of November 2022, wherein it posed 5 questions for determination as follows. The questions as posed by the claimant are stated on the face of the judgment. To save the time of the court, I will skip the reading out of it. Upon determination of those questions, the claimant praised the court for the reliefs set out as follows. Again, the reliefs as sought by the claimant are stated on the face of this ruling. I shall be skipping the reading out of same to save the time of the court. We have 7 reliefs stated therein. The originating summons is supported by an affidavit of 37 paragraphs deposed to by one Sufyan Bello, who claimed to be a member of the claimant. Annexed as exhibits to the affidavit in support are 3 documents, namely copies of Trade Union Act 2004 as Exhibit A, 2 copy of letter signed by the first defendant dated 18th of March 2013 as Exhibit B, and 3 letter of appointment of first defendant as caretaker chairman of heavy duty of NURTW Ajaokuta as Exhibit C. In reaction, the defendants filed a 40-paragraph counter affidavit on the 18th of October 2023. The deposition of the first defendant is that he is a former member and executive of the NURTW, but he has ceased to be a member since 24th of February 2021, when he tendered his letter of resignation. According to him, that prior to this date, he had orally informed the chairman of the claimant when he visited him, that says the chairman, with one Mohammed Ibrahim, of his intention to resign. The first defendant denied the allegation that he factionalized the union or that he plotted to remove the branch chairman in 2018 or that he lobbied to be appointed as chairman of the branch. He also denied that he was appointed as caretaker chairman of Heavy Trucks Industrial Branch or that he conspired with anyone to apply for the creation of Heavy Trucks Industrial Branch, and denied that such union existed in the constitution of NURTW. The further deposition of first defendant is that after he resigned from NURTW on the 24th of February 2021, the second defendant, an association, he denied that the said second defendant self-employed person. It says the obligated or bound by the rules, regulations, or constitution of NURTW, or for payment of dues to NURTW, or buying of receipts or tickets from NURTW. The letter of resignation of the first defendant as trustees of NURTW, dated the 24th of February 2021, the certificate of incorporation of the second defendant, dated the 28th of April 2021, and copies of the Trade Unions Act Supra were respectively annexed to the affidavit, counter affidavit as Exhibit ISA 1, Exhibit ISA 2, and Exhibit ISA 3. The claimant further and better affidavit of 26 paragraphs and a reply on points of law was deemed filed on the 26th of January 2024. The claimant maintained that due to the prevalence of heavy trucks in the industrial area of Ajaokuta, the heavy duty section was carved out of the Ajaokuta branch of the NURT. He further alleged that the Road Transport Owners Association of Nigeria, that is RTON, and Road Transport Employers of Nigeria, that is RTEAN, are transporters in the industries, and that both unions are under the statutory jurisdiction of NURTW. The claimants maintained that the first defendant is still a member of NURTW till date, and denied that the letter of resignation of first defendant was received by the claimants. It was further alleged that there is no resemblance between the signature of the first defendant on the motion dated the 21st of June 2023 and his signature on Exhibit B. The further contention of the claimant is that the activities of the defendant within Ajaokuta Steel Company mining and quarry sites are in conflict with that of NURTW that have resulted in several clashes and fracas between members of both parties. Now, it is noted that the written address of counsel for the defendant was started with a preliminary issue that paragraphs 4 to 36 of the affidavit in support of the originating summons are incompetent, and counsel prayed the courts to strike out the said paragraphs. The preliminary issue is anchored on the infraction of the provision of Section 115, Sub 1 and 2 of the Evidence Act 2011. Section 115, Sub 1 provides, I quote, every affidavit used in the court shall contain only a statement of facts and circumstances to which the witness deposes, either of his own personal knowledge or from information which he believes to be true. Sub 2 reads, I quote, an affidavit shall not contain extraneous matter by way of objection, prayer, or legal argument or conclusion. An affidavit is made by a deponent stating clearly his factual position on the issue. For consideration, see Eze versus Unijust, 2017, 17 Nigeria Weekly Law Report, Part 1593, at page 1. It is settled law that an affidavit shall contain only statements of facts and circumstances and devoid of extraneous matters such as objections, prayers, legal arguments, or conclusion. See Attorney General Adamawa State versus Attorney General Federation, Lokoja versus Adeleke, Ahmed versus CBN, citation all supplied. The case of FGN versus AIC Limited, 2006, for Nigeria Weekly Law Reports, Part 970 at 337, cited by counsel for the defendant is also apposite. The litmus test for determination of the presence of facts and circumstances in an affidavit was re-echoed by UI for JSC in General and Aviation Services Limited versus Tahal, 2004, 10 Nigeria Weekly Law Report, Part 880, page 50 at 73, in this incisive and illuminating words. I quote, the test for knowing facts and circumstances is to examine each of the paragraphs supposed to in the affidavit. If it is such that a witness may be entitled to adduce them in his testimony on oath and are legally admissible as evidence to prove or disprove the facts of or of circumstances. This means that affidavit evidence, like oral evidence, must, as a general rule, deal with facts and avoid matter of inference or conclusion which fall within the province of the court, or objection, prayer, or legal arguments which must be left to counsel. If therefore affidavit evidence is in the form of conclusion, inference, legal arguments, prayer, or objection, it raises no fact which needs to be controverted, but is simply regarded as extraneous to the determination of factual disputes. End of quote. I had undertaken a cursory examination of the said paragraphs to discover if the paragraph flouted or respected the law. It is paragraph 16 to 20 and paragraphs 32 to 36 of the affidavit in support of the claimant applicant of the claimants that are hosting legal arguments and conclusions. It is my humble view that the deposition come squarely with the domain of legal arguments, which ought to be left to counsel to urge on the court. By the same token, the depositions also qualify as conclusion, which is within the prerogative right of the courts to draw from the facts and legal arguments. This has dismal consequence on the affidavit. The paragraphs have violated or infringed on the provisions of Section 1151 and 2 of the Evidence Acts 2011 displayed above. The penalty for such paragraph is striking out. In due allegiance to the law, I hereby strike out the said offensive paragraphs of the affidavit in support of the motion. Now, it is not in doubt that the dispute in the suit relates intricately on the construction and interpretation of Section 34.3, Part B, Item 16, Third Schedule of the Trade Unions Act, Cap T 14, Laws of Federation of Nigeria 2004. In his written address, counsel for the claimant restated the settled principle of law on interpretation of statutes that the express mention of words in a statute implies the exclusion of words not expressly mentioned in the statute, that is, expressio unis es exclusio alteris. End of quote. Counsel argued that in relation to the said Section 34.3, Part B, Item 16, Third Schedule of the Trade Unions Act, National Union of Road Transport Workers and URTW was expressly mentioned as a registered trade union, but that the second defendant, Trustees of Kogi State Truck Owners Association in Nigeria, was never mentioned as a registered trade union in the Trade Unions Act supra. Citing the case of Iron versus EIE, 1993, Nice Supreme Court of Nigeria Judgment, Part 1 at 53, counsel further submitted that where jurisdiction is specifically donated to a person, only that person with the prescribed power or jurisdiction is permitted in law to perform within the powers and or jurisdiction given. He argued that the second defendant, not being one of the registered trade unions listed in the Trade Unions Act supra, the NURTW is the registered and recognized trade union with the jurisdiction over, I quote, all workers engaged in transportation of passengers and goods by road, excluding the transportation of petroleum by road and transportation undertaken by self-employed persons, end of quote, at Ajaokuta, and that the drivers in the second defendants association not being self-employed for transportation of goods in Ajaokuta fall within the jurisdictional scope of the claimant. It is the further submission of counsel that the tried position of law is that where the provisions of a statute are clear and unambiguous, the courts have been enjoined to give such provisions their ordinary meaning and to restrain from reading into the provisions words which are not found in them. The argument canvassed by counsel is that the claimant's scope of jurisdiction is clearly set out in the Trade Union Act, and the defendants are statutorily within the scope of jurisdiction of the claimant so far as the nature of their business is transportation as defined under the Act. Citing Section 4145 sub 1 of the 1999 Constitution as amended, counsel argued that fundamental right principles do not operate in absolute terms, and that being members of NURTW, they are bound by the rules and regulations of the claimant. On his part, counsel for the defendants considered that by virtue of Section 34 sub 3, Part B, Item 16, Third Schedule of the Trade Unions Act supra, NURTW, the claimant is a registered union. However, he argued that the second defendant is an independent association recognized under Section 40 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, and contends that the first defendant and members of the second defendant are self-employed persons who formed the association to protect their collective interests and welfare. Counsel further argued that being self-employed person engaged in transportation, the defendants are exempted from the scope of jurisdiction of the claimant. He further contends that the jurisdictional scope of the claimant includes the defendants who are not their members, employees, or affiliates. Citing the cases of Nestral PLC versus Nupeng, 2012, 29 Nigeria Labor Law Report, Part 82 at page 90, and the case of Panya and Igboro versus Sea Trucks Nigeria Limited, 1995, 6 Nigeria Weekly Law Report, Part 299 at page 35. The further argument of defendants' counsel is that by virtue of Section 40 of the 1999 Constitution Supra and the principle of volunteerism, no person, including the defendants, can be forced or compelled to join or belong to any association or trade union. Counsel argued that pursuant to Exhibit ISA 1, the letter of resignation, the first defendant has ceased being a member, worker, or executive of NURTW from 24th of February 2021. Counsel further cited Section 52 of the Trades Union Act on the definition of a worker and argued that by virtue of the scope of jurisdiction of the claimant as provided by Item 16 of Part B, Third Schedule of the Trades Unions Act, Supra, not all workers that are engaged in transportation of passengers and goods by road are within the jurisdiction of the claimant. Counsel maintained that the second defendants are self-employed persons engaged in transportation business and are not within the jurisdiction of the claimant. Now, as correctly submitted by counsel for the contending parties, the source of jurisdictional scope of trade unions in Nigeria is derived from the third schedule, parts A, B, and C, as contained in the Trades Union Act, Cap T 14, Laws of Federation, 2004. Jurisdictional scope is therefore statutory regulated, compartmentalized, and well-defined. In other words, the limits within which jurisdiction is to be executed by trade unions is in itself statutory. See the case of Osawe versus Registrar of Trade Unions, 1985, 1 Nigeria Weekly Law Report, Part 4, 755. One of the cardinal principles in the restructuring of trade unions relates to the need of compatibility of the trade unions in terms of products, skills, services, and conditions of employment. Therefore, the argument by counsel for the defendants that Part B, Item 16, Third Schedule of the Trade Unions Act, Supra, seems to be limiting the constitutional protected and guaranteed fundamental human rights as enshrined by Section 40 of the 1999 Constitution is misconceived and hereby discountenanced. The jurisdictional scope of the claimant as provided and listed in Third Schedule, Part B, Item 16 of the Trades Union Act, Supra, is restated as follows. I quote, all workers engaged in transportation of passengers and goods by road, excluding the transportation of petroleum by road and transportation undertaken by self-employed persons, end of quote. The court has held severally that unionization is industry-based. See the Nigerian Merchant Navy Officers and Water Transport Senior Staff Association versus Nupeng on reported suit number NICN/ABJ 104 2011, where this court held that the workers in Lamneco Nigeria Limited are more compatible with the claimants as they are workers in maritime sector by training, though their services are offered to the oil and gas sector. In Nupeng versus Maritime Workers Union of Nigeria, 2015, 61 Nigeria Labor Law Report, Part 214 at 403, it was held that employees of GAG mining services on board the vessel FPSO Senjebej that is engaged in oil and gas industry are workers in the maritime industry and so eligible to be unionized by MWUN. In Food, Beverage and Tobacco Senior Staff Association versus Royal Salt Limited Kirikiri Lighter Terminal Apapa 2009, 16 Nigeria Labor Law Report at part 43 at page 92, the court held the Food, Beverage and Tobacco Senior Staff Association cannot unionize workers who are not in the food industry, as salt is a chemical substance from manufacturing industry. The claimant had alleged that the first defendant is a member and its executive. In fact, this assumption runs through the claimant's depositions and the submissions of her counsel. On the flip side, the first defendant maintained that he is no longer a member or an executive of the claimant and that he had tendered his resignation letter after which the second defendant was incorporated. In essence, the fundamental issue at stake to resolve is whether or not the defendants are members of the claimant. Where a claimant alleges that a person is an existing member of a trade union, the burden of proof lies with the claimant to substantiate this assertion. Proving membership in a trade union involves presenting credible evidence that demonstrates a person's active membership status. In other words, only concrete evidence can show if indeed the first defendant is still a member of the claimant and if the second defendant are members of the claimant. Even the description of the first defendant in paragraph 4 of the supporting affidavit, as I quote, a registered member of NURTW, Ajaokuta branch and trustee 2 for many years, end of quote, is not conclusive that the first defendant is still a member. It is true that proof of membership in a trade union requires a combination of documentary evidence, financial records, and possibly testimonial evidence, of all which must align with legal standards and requirements set forth in relevant labor laws and regulations. On the issue of volunteerism, I've taken liberty to reproduce Section 12(4) of the Trades Union Act that provides as follows, I quote, notwithstanding anything to the contrary in this act, members of a trade union membership of a trade unions by employee shall be voluntary, and no employee shall be forced to join any trade union or be victimized for refusing to join or remain a member, end of quote. This clearly provides that membership of a trade union by an employee is voluntary. In other words, he has the freedom to decide which union he wishes to belong. However, as claimant counsels had correctly submitted, the right of an employee to decide which union he belongs to, which union he wants to belong, is not absolute, but must be exercised within the limits of the Trade Unions Act, supra. Apart from challenging the membership of the defendants, the claimants in supporting affidavit made spurious allegations against the first defendant, bordering on conspiracy to create a Ajaokuta native town industry heavy-duty branch, attempted removal or impeachment of sitting branch chairman in 2018, the credibility of the first defendant's letter of resignation. See paragraphs 5, 6, 7, 8, 9, 10, 11, 12, 13, 26, 27, 28, 29, 30, and 31 of the supporting affidavits. In the reswan further affidavit in support of the originating summons, it was alleged that the operation and all activities of the defendants within Ajaokuta Steel Company Limited have resulted in clashes and fracas between operatives or members of both parties that led to the arrest of the officials of the claimants by the police. See paragraphs 24 and 25 thereof. I should remark that as stated in the reswan further affidavit, the letter purportedly written by the claimant solicitors dated 4th of June 2021 was not attached as Exhibit NURTW 1. Now it is trite that originating summons is meant to resolve disputes where facts are fairly not in dispute. In paragraphs 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 24, 25, 27, 36, and 37 of the counter affidavits, the defendants had challenged the depositions of the claimant that the first defendant is a member or executive of the claimant, and the various allegations made by the claimant were denied by the defendants. The point is that in Adeniyi versus APC and others 2014 Law Pavilion Electronic Law Report at 24214, relying on National Bank of Nigeria versus Lokoja, 1978, 9-10, Supreme Court at 59, it was held thus, I quote, "The principle has become trite that the originating summons procedure is not for causes in which facts remain hostile and in conflict. The procedure is ideal for, the determination of short and straightforward questions of construction and interpretation of documents or statutes. It is never the applicable procedure in controversial cases where the facts on which the court is invited to construe or interpret the documents or legislation is in relation to remain violently in conflict," end of quote. See also Femfa Oil Limited, thank you, versus AG of the Federation and another. And the case of Njideka Ezekwe versus Chief Benson Chooks, Nwalu, and other citations supplied. As I stated earlier, the issue of union membership and the type of business the defendants are engaged in are fundamental and crucial in the instant case. Only pleadings could have resolved these issues of facts, but no, lawyers want shortcuts and originating summons. I should remark that the case of Maritime Workers Union of Nigeria versus Incorporated Trustees of Freight Forwarders Transport Association, unreported NICN/PHC/48/2022, delivered on the 14th of November 2023, cited by the Claimants Council to buttress his submission for the grant of the reliefs being sought, is distinguishable from the instant case. In that case, pleadings were filed by the parties, and the case was decided based on credible evidence adduced at trial. In the instant case, in choosing to come by way of an originating summons, the claimant has delimited its case to just the question posed and the facts as presented in the affidavit evidence. The matter must be resolved within the limits of the claimant's affidavit evidence, since by law, having to come by way of originating summons instead of a complaint does not signify that the case is incompetent. See Sylvester Eze versus University of Jos, NJC versus Honorable Justice Jubril Babajide Aladejano, citations supplied. I am also not unmindful that the claimant has sought declaratory reliefs in the suit The implication being that the burden for him to prove the allegation leveled against the defendant exceeds the regular burden provided in sections 131 and 132 of the Evidence Act 2011. The settled position of law from time immemorial is that even though the power to make a binding declaration of right is discretionary in nature, a court will only grant declaratory reliefs sought in an action principally on the basis of the evidence adduced by the claimant without recourse to the evidence called by the defendants. The burden of proof on the claimants in establishing a declaratory relief to the satisfaction of the court is somewhat heavy, in the sense that such relief is not granted, even on the admission of the defendant, as the claimant must lead credible evidence in proof of the declaration of right it seeks from the court. See the authorities of Ndayako versus Dant, Labanji versus Omokwenu, citation supplied. At this juncture, it is considered pertinent to restate the time-honored cardinal principles of judicial process that the relief sought by a claimant in an action is fundamental to the fate of that action. Indeed, the relief sought is the bedrock of life and life wire of an action. Therefore, where the relief sought is uncertain, uncategorical, or is not supported by evidence on record, or does not reflect the course of action, the entire process, exercise, and proceedings becomes futile, as there will be nothing for the court to grant at the end of the day. The court will be compelled to throw out the case. See Joe Godale Co. Limited versus CDB PLC, and Uzoku versus Ezionu, citation supplied. Keeping this principle of law in focus, the claimant has failed to prove its allegations that the first defendant and the members of the second defendant belong to NURTW, that the second defendant is engaged in an organized transportation of sands, chipping, stones, and laterite from Ajaokuta Steel Company, or that the activities of the defendants have resulted in several clashes and fracas between the two parties, and I so hold. On the basis of the foregoing analysis, therefore, I must and I hereby resolve the issues for the determination in this suit against the claimants. My decision is therefore that the claims of the claimants is lacking in merit and in substance. It fails in its entirety. It shall be, and it is hereby accordingly dismissed. Parties shall be at their respective courts.
Dismiss the claimant claim. I thought you were going to order for plea. Quite grateful, my lord.
On behalf of the defendant, we reject
Well, I will find a way to transmit the ruling, or whatever we'll call that in English, to the Lokoja division, probably by next week, so that you can have a copy. Okay, thank you. The courts shall rise. Thank you.
Yes, me. Yeah, I was thinking that I was going to overplay this. You understand? But now dismiss the case.
Mr. Onoja, you are the judge in this matter. Did you not hear that a case can still be heard even though, since it is not, or whoever is making that comment?